Good afternoon. Welcome to our latest healthcare webinar. Today we're going to be talking about healthcare fraud and abuse issues, including applying those laws. My name is Kim Stanger. I'm the head of the firm's Health Law Group, and we look forward to discussing these issues with you today. This is just the latest in our webinar series. We've got future webinars coming up. Recently, we've been focusing a lot of the no surprise billing rules and some of those related stuff. So we're kind of turning back to kind of the usual customers, including in a couple of weeks, we're going to be talking about HIPAA, information blocking 42 CFR Part 2. We've got other programs coming up. If you are not receiving those alerts, by all means, let us know. We'll make sure you get the alerts to sign up and participate in those webinars. So today, I'm going to be talking about some of the key statutes dealing with federal fraud and abuse issues. And then I'm going to be applying those statutes to some of the common situations out there, the ones that raise common questions that clients come to me for. In addition, if we have time, I'm going to talk a little bit about your report and repayment obligations if you do have a problem with one of those statutes. A word of caution, after all, I'm an attorney. This is a quick overview of the most relevant federal laws and regulations. Now, in all of your states, you're also going to have your own state laws. So make sure that you're also familiar with the state laws, including the federal laws we're going to talk about today. Now, I'm going to hit the main ones that we deal with on a regular basis, but depending upon your particular circumstances, there may be additional laws that apply. In addition, the application of the laws that we're going to talk about today will depend upon your particular circumstances. You know, are you a physician versus another type of provider or so forth? It will also depend upon the payer involved. The rules that we're going to talk about today largely apply if you're participating in Medicare or Medicaid. But if you're not a Medicare or Medicaid provider, then probably you don't have the same requirements. It can also depend upon your particular jurisdiction, especially if you've got different state laws. So make sure you confirm the applicable laws and the requirements when applying the law to your facts. If you have any questions about the stuff we're talking about today, I'm not going to have time to take questions on the program, plus we're recording it, but you're welcome to submit those questions using the chat feature, and I promise I will do my best to respond to those offline. You can either use the chat feature or the Q&A feature through the webinar, or you can simply shoot me an email. In addition to the PowerPoint slides, you should have received an email that has links to various supplemental resources, including some pretty good resources from the Office of Inspector General, as well as several articles that I or others at the firm have authored dealing with the issues that we're going to talk about today. If you did not receive those, then feel free to reach out to Charles, and he can make sure that he gets that information to you. All right. With that said, let's talk about key fraud and abuse laws. The ones that I wanted to talk about today are the False Claims Act, the Anti-Kickback Statute, the Eliminating Kickbacks in Referrals Statute, or ECRA, the Ethics in Physician Referrals Act, more commonly known as STARK, you know it and you love it, the Civil Monetary Penalties Law, and certain healthcare criminal statutes. These are used because the government may want its money back. We're looking at depleting the Medicare trust fund before long, and so the government is actively engaged in trying to recoup money where it can appropriately do so. In fact, in February, the government announced that its recoveries in fiscal year 2021 were the second largest ever. They recovered $5.6 billion. The primary source of recovery, the weapon that the government uses, is the False Claims Act. The False Claims Act says that you cannot knowingly submit a false claim for payment to the federal government. And by means of a false claim, they're talking about if you submit a claim for services that really weren't provided as they claimed, but it could also apply in other contexts, including the government has indicated if you're providing substandard care, because the government only pays for appropriate care. And if you're providing substandard care and you submit that claim, then the government has argued that that would be a false claim. In addition, the ones that come up that I see quite often are the situation where you have submitted the claim when you have failed to comply with the regulations that condition the submission of that claim. For example, STARK or the Anti-Kickback Statute. If you submit a claim that you were prohibited from submitting under STARK or the Anti-Kickback Statute, then that would be a false claim and the government can come after you for that. Now, there's those affirmative situations where you submit a false claim to the government, but the False Claims Act also extends to situations where you received an overpayment or you submitted a claim improperly, and you fail to report and repay that overpayment within the later of either 60 days from the date 60 days from the date that you identified that overpayment, or the date that the cost report is due. So when it comes to the government, it is not finders keepers. If you got paid when you shouldn't have got paid, you have an affirmative obligation to report that back to the government. Well, what happens if you violate the False Claims Act? Well, at the very least, you have to repay plus interest, plus you could get hit up with civil monetary penalties and that amount to, currently it's about $11,000 to $23,000 per claim submitted. Now note that that's per claim. That's not per mistake. You had the same mistake that applied to, 1,000 claims. Each one of those separate claims you submitted is potentially subject to this $11,000 to $23,000 penalty. Now that, with a little asterisk there, that means that is adjusted annually on a cost of living. So the number for 2022 is $11,803 to $23,607. In addition to that civil monetary penalty under the False Claims Act, you can get hit up with an administrative penalty under the Civil Monetary Penalties Law of $22,000 if you fail to return an amount that you were supposed to pay. In addition to that, you can get hit up with treble damages. In addition, you can be excluded from Medicare and Medicaid, which is kind of the death knell for practicing in healthcare pretty much these days. And we're going to talk a little bit more about that later. Importantly, under the False Claims Act, if you violate that, then you could be subject to what's called a qui tam lawsuit. A qui tam lawsuit is one in which a private citizen can sue you on behalf of the government. So they sue you. The government may or may not intervene in that. If the plaintiff, that qui tam plaintiff, that private person, wins, then they get a percentage of the recovery. Now that could be brought by former employees or current employees. It could be brought by competitors. It can be brought by pretty much anyone out there who wants to assert those claims on behalf of the government. And that is a significant way that the government is able to identify potential issues. The government has indicated recently that its priorities for this year, certainly pandemic-related payments are a huge issue for the government. There's a lot of money that went out. And if you didn't comply with those rules or you got the money improperly, then the government can come after you for that. Telehealth is a big target for it because, again, probably because it's pandemic related, the government broadened the scope of services for which you would pay under telehealth, and they were concerned that there was a lot of fraud and abuse going on for that. Cybersecurity issues is another one. The DOJ recently announced an initiative in which it was going to go after entities under the False Claims Act if they do not have appropriate cybersecurity policies in place. If they're federal grantees or contractors and they represent that they've got appropriate securities in place and they don't, then the government could use the False Claims Act to go after them. Medical necessity is another one. And then, of course, kickbacks and inducements, always a favorite for the government. The government can identify and come after you from self-reports from, qui tam whistleblower cases, like we mentioned. In addition, the OIG and the DOJ use complex analytic programs in order to identify potential overpayments. And like I said, you have an affirmative obligation to self-report. You've got a narc on yourself, so the government can come after you in the wake of a self-report. That's the first statute. That's the government's main weapon to come after you. Another one is the anti-kickback statute. The anti-kickback statute says that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services that are covered by a government program unless the transaction is structured to fit within a regulatory safe harbor. What are the penalties? Well, this is a felony. You can go to jail for this one. False Claims Act, that's just a civil penalty, but under the anti-kickback statute, that's a penalty. It's up to 10 years in prison, a $100,000 criminal fine. In addition, you can get hit up with a $112,000 civil penalty. You can get hit up with treble damages. And also, you can be excluded from Medicare and Medicaid for an anti-kickback statute violation. In addition, an anti-kickback violation is an automatic violation of the False Claims Act, which means you can be subject to any of those penalties that are also associated with the False Claims Act, including you can be subject to a qui tam litigation. Now, a couple of comments concerning the anti-kickback statute. First, note that it applies to anyone who knowingly and willfully offers, pays, solicits, or receives remuneration. This can apply, it's not limited to physicians, it can apply to anybody. And the government's gone after, marketers, C-suite people in your C-suite, anybody who is engaged in these kickback relationships, the government can potentially come after. Note that it applies to offering, paying, soliciting, or receiving. It applies to both sides of the transaction, so the government can go to both sides. It applies to remuneration. Now, remuneration is very broad. It's not just money. It's anything that has significant value can constitute remuneration. It certainly can be money, but it could be free or discount items or services. It could be investment opportunities. Anything of value potentially implicates the anti-kickback statute. Now, importantly, the federal anti-kickback statute is limited to any program or this arrangement in order to induce referrals for items or services that are payable by government programs like Medicare, Medicaid, and so forth. The federal anti-kickback statute generally would not apply to inducements for private pay business, but you have to be a bit careful because the government said, you may have a situation where you want to pay some kind of inducement in order to get referrals for the private pay, but you're also getting the federal program referrals from that entity. In those situations, the government said that simply carving out the federal programs may not protect you. Because if you're paying an incentive to get the private pay business, then you're probably also going to get the government pay business from that entity. And therefore, the payment is really to get the government business also. And therefore, the government reserves its right to come after you. So be careful about those situations. Now, it applies to any of these transactions to generate referrals for federal program business, unless you structure the deal to fit within a regulatory safe harbor. If you fit within the regulatory safe harbor, no surprise, you are safe. On the other hand, if you fail to fit within the safe harbor, it does not necessarily mean that you violated the anti-kickback statute because it's an intent-based statute. You have to knowingly and willfully offer, pay, solicit. Now, it is intent-based, but be careful. That doesn't mean that you have to intend to violate the law. It used to be that way in the Ninth Circuit, but the government revised it to confirm that no, ignorance of the law is no excuse. All you have to do is intend to enter into that arrangement that induces those services. Now, if you don't fit within a safe harbor, it's not necessarily a violation, but then the test becomes, is one purpose of that arrangement to induce referrals? So it's called the one purpose test. Now, the problem with that is that's pretty hard to defend against. If you've got a financial relationship with a physician or another person or another entity that's sending you lots of business, it's kind of hard for you to come in there and prove that not one purpose of that arrangement was to get these referrals. So be careful about that. So the way the anti-kickback statute works is if you have remuneration plus an intent to induce referrals for items or services payable by federal healthcare programs, that is an anti-kickback violation. You're in the red there, unless you can structure the deal to fit within a regulatory safe harbor or you get a favorable advisory opinion. The anti-kickback statute has a bunch of safe harbors applicable to different types of situations. Those are all set forth at 42 CFR 1001.952. For example, there's a safe harbor for bona fide employment relationships. It's pretty broad. There's one for personal services contracts, independent contract. Security technology. There are new ones effective January of 2021. The government issued new safe harbors that apply to value-based care arrangements, care coordination arrangements, and certain patient engagement incentives. Now, for each one of these safe harbors, however, each of those comes with a bunch of conditions. And in order to fit within the safe harbor, you have to satisfy all of those conditions that are associated with that particular safe harbor. So if you want to know whether or not a particular transaction fits within the safe harbor, you got to call up those regulations and look at the safe harbor and walk through the elements to make sure that you comply. Now, the failure to comply with all of those elements doesn't necessarily mean that you violated the anti-kickback statute. It just means that you don't have safe harbor protection. So the test would theoretically be then, was one purpose of the transaction to fit within the regulatory safe harbor? Another alternative is you can go to the OIG and request an advisory opinion. So you can go to them and you can say, this is the deal we want to do. We want to find out in advance whether or not this would violate the law or whether or not you'd come after us for this. The OIG usually takes a while to get the advisory opinions, usually longer than the clients wants. But the good news is that the OIG lists all of its advisory opinions on its website. So if you're contemplating a particular transaction, you don't think you fit within a specific regulatory safe harbor, you could go on to the OIG's website here, look for other similar advisory opinions for similar transactions. And if you structure the deal to fit within a favorable advisory opinion, you're probably going to be safe. Now, emphasize probably, because the regulation and statutes affirm that the advisory opinion is only binding on those parties to that advisory opinion, so not necessarily others. But if you come close to that advisory opinion, chances are you're probably going to be okay. All right, that is the federal anti-kickback statute, very broad. Now, there's a new one out there, relatively new anyway, that you need to make sure you're aware of, especially if you're operating in a laboratory. As part of the government's crackdown on opioid abuse, they passed the Eliminating Kickback and Recovery Act, or ECRA. ECRA is kind of like the anti-kickback statute, only on steroids. The anti-kickback, or the Eliminated Kickback and Recovery Act, or ECRA, says you cannot solicit or receive, pay, or offer any remuneration in return for referring a patient to a laboratory, recovery home, or clinical treatment facility unless the arrangement is structured to fit within a regulatory exception. Couple of comments here. It's very similar to the anti-kickback statute, but it's only limited to certain types of services, specifically laboratories, recovery homes, or clinical treatment facilities associated with rehab for opioid and drug abuse, that type of stuff. Now, the reference to laboratory, though, is broader than you might think. It's not labs just dealing with opioid situations. It, at least as currently interpreted, it applies to any laboratories. So if you're operating any kind of a lab or getting referrals for lab services, you need to be concerned about ECRA. A couple of other points. Note that ECRA, remember the anti-kickback statute, it only applies to referrals for items or services that are payable by federal healthcare programs. So you usually didn't have to worry about it if it's a private pay arrangement. Not so with ECRA. ECRA applies to even private pay situations as well as government programs. So it's broader than the anti-kickback statute in that regard. What are the penalties for violating ECRA? Well, again, it's a felony. You can go to jail for up to 10 years. In addition, you have to pay a $200,000 criminal fine. Probably would also be subject to the anti-kickback statute if it involves Medicare, Medicaid, or other government programs. The bottom line here is you have to be very, very careful about ECRA if you're involved at all with labs. Now, ECRA does have a limited number of safe harbors in the statute, but it's not, those safe harbors are not nearly as extensive as the anti-kickback statute. So if you're going to do any kind of a transaction with potential referral sources involving your labs, make sure that you consider ECRA and the potential implications there. Unfortunately, we don't have implementing regulations concerning ECRA, and so we're pretty much just stuck with the statutory safe harbors, and those are fairly narrow. All right, the next one we want to talk about is the Ethics and Patient Referrals Act, or STARC. A lot of misunderstanding about STARC, what it is, what it covers. The best way to understand STARC, I think, is to go back to why it was implemented. Back in the 80s and 90s, the government switched from a pay for service type situation and they reduced the income to physicians. And so physicians were out there looking for ways to supplement their income. The government started noticing that they were getting more and more claims for ancillary services, particularly labs, diagnostic imaging, those types of things. And the government say, well, why are we suddenly getting more and more of these? They did a study and they concluded the reason is because physicians who are looking to supplement their income were then opening up their own labs or imaging centers or PT clinics or other things like that. And they were sending patients over there. And the government was concerned that they were abusing that in order to get more government money. And so Representative Pete Stark from California said, well, we can put a stop to that. So they passed the Stark Law. Stark says that if a physician or a member of the physician's family has a financial relationship with an entity, that physician may not refer the patients to that entity for certain designated health services payable by Medicare or Medicaid. And if the physician does happen to refer those patients there for these designated health services or DHS, and that entity may not then bill for those services. If they do, they've got to repay it, unless that arrangement fits within a regulatory safe harbor. Now, a couple of points about Stark. It's similar but different from the anti-kickback statute. Like the anti-kickback statute, it applies to items or services that are payable by Medicare or Medicaid, so not private pay business. Unlike the anti-kickback statute, it's narrower in who it applies to. It applies to physicians or members of a physician's family. It only applies if there's a financial relationship between the physician or the physician's family and this provider of designated health services. Stark doesn't prohibit that financial relationship. Stark just says if you've got that financial relationship, physician, you can't make referrals for designated health services to that entity unless you structure the deal to fit within a regulatory safe harbor. Now, remember, the anti-kickback statute was intent-based, so it wasn't essential that you fit within the safe harbor so long as you didn't have improper intent. That is not the case with Stark. Stark is what we call a strict liability statute. It doesn't matter whether you had good or bad intent. You either comply or you don't comply. What happens if you don't comply with Stark? Well, the government does not have to pay for services that are provided per an improper referral in violation of Stark. In addition, if you did get paid improperly, then you've got an affirmative obligation to narc on yourself. You have to repay the government within 60 days. If you fail to do so, you can get hit up with civil penalties up to $27,000 per claim, or if you're a physician or trying to come up with some scheme in order to avoid Stark, you can get hit up with a penalty of $174,000 per scheme. Now, note that that is per claim. Again, let's say that you're a hospital, you come up with this non-compliant Stark relationship with a referring orthopedist, and that orthopedist over the years has sent you 200 different claims, to have made 200 different referrals that you've then submitted or billed Medicare or Medicaid for. In those situations, each one of those claims, each one of those 200 claims is subject to this different penalty. So the penalties for a Stark violation can add up very quickly. If you've got a Stark violation, there's a good chance you've also got, well, you do have a False Claims Act violation, assuming that there is improper intent. So you could be subject to all of those penalties that appeared under the False Claims Act, including the potential for a qui tam litigation. In addition, if you've got a Stark violation, there's a good chance you've also got an anti-kickback violation, which can subject you to the criminal penalties and the things we talked about under the anti-kickback statute. So remember, though, however, Stark only applies to referrals by a physician to entities with which a physician or their family member has a financial relationship. For purposes of Stark, a physician is an MD, DO, oral surgeons, dentists, podiatrists, optometrists, or chiropractors. So, for example, Stark would not apply to APPs, nurse practitioners or physician assistants, unless the physician was really pulling the strings and requiring those entities to make those referrals. So it was really the physician who was making the referrals. Stark also applies if there's a financial relationship with the physician's family member. The theory there is that the physician may make the referrals in order to benefit a family member. For purposes of Stark, the family member is a spouse, parent, child, sibling, step-parent, stepchild, grandparent, grandchild, in-law, etc. So, for example, if you're a hospital and you're employing a physician's spouse, you need to make sure that that spouse's contract complies with Stark, as well as any relationship you might have with that particular physician. Now, the anti-kickback statute, it applies to referrals for any items or services payable by Medicare or Medicaid or other federal healthcare program. In contrast, Stark only applies to referrals for certain designated health services, payable in whole or part by Medicare or Medicaid. So it only applies to the referrals for these specific types of issues, including inpatient and outpatient hospital services, outpatient prescription drugs, clinical lab services, physical, occupational, or speech therapy, home health services, radiology and certain imaging services, radiation therapy and supplies, durable medical equipment, and so forth. The key here is if you've got any kind of a financial relationship, and financial relationship is very broad. It includes anything of value, whether it's just money or anything that is of value. Could be free or discounted items or services, whatever. Okay. If you've got any kind of that relationship with a physician or a physician's family member, and that physician is going to be making referrals for any of these designated health services, you need to make sure that you consider the Stark implications. So Stark applies if there's a financial arrangement with a physician or their family member, and there's going to be referrals from that physician for those designated health services. If there are, then it's a Stark violation unless you structured the deal to fit within one of the regulatory safe harbors, or you obtain a favorable advisory opinion, similar to the anti-kickback statute. Under Stark, there are different safe harbors depending upon the type of financial relationship that's involved. There is a safe harbor, or a series of safe harbors that apply to both ownership and compensation arrangements. The most important of these are the physician services safe harbor and the in-office ancillary services exceptions. These are the exceptions that apply to within a group. If a group is going to make referrals back and forth within the group, well, that is a referral for purposes of Stark. If you're ordering services or referring services to another provider in your group, or for the group to bill for those services, that's generally a referral under Stark, and therefore Stark's going to be implicated. But as long as you structure the deal to fit within the in-office ancillary services exception or the physician services exceptions, then that's the safe harbor that allows referrals within the group. In order to get the benefit of those safe harbors, though, you're going to have to qualify as a group practice. I'm going to try to talk about those a little bit later if we have time. In addition, Stark has safe harbors that apply only to ownership arrangements, not necessarily compensation, but just ownership arrangements. The most important of this, for this one, is the rural provider exception. So generally, Stark would say, okay, physician, let's say a physician goes out and purchases or establishes a separate imaging center, and he wants to refer his patients over to that separate imaging center for services. Well, if those are Medicare and Medicaid patients, services that are covered by Medicare and Medicaid, those are probably going to fit within designated health services. So Stark would say, physician, you can't make those referrals over to this separate entity unless you can fit within a safe harbor, and that's really hard to do. But there is one safe harbor that applies in those situations for rural providers. If that provider is located in a rural area. A rural area is outside a metropolitan statistical area, and you provide more than 75% of your services to patients from outside that metropolitan statistical area. Stark thought that the law assumed that, well, for certain types of providers in rural areas, we've got to allow the physicians to set up these ancillary services, set up these other entities, because nobody else will. And if we prevent the physicians from doing that, then nobody's going to set these up. These services aren't going to be available. So they created this exception that allows physicians to have an ownership interest in a separate entity as long as it's in a rural area, and then the physician can go ahead and make those referrals over there. There's also an exception for the whole hospital. This is the one that allows physicians to make referrals to a physician-owned hospital, but they've limited those going forward. Existing ownerships are grandfathered in generally, but they've limited those investments going forward. In order to fit within the safe harbor, like the anti-kickback statute, you got to satisfy all of the criteria. Close is not enough, right? You got to satisfy all of the particular criteria for those safe harbors. Now, if you're just dealing with a compensation arrangement with a physician, which is generally what most of you are dealing with, then you've got a whole bunch of other safe harbors that apply, including a safe harbor that applies to employment relationships, one that applies to personal services or independent contractor relationships, a new one that effective January of 2021, they came up with a new safe harbor that applies to remuneration to a physician for services so long as the remuneration is less than $5,000 per year. This is a good one because it may help avoid those situations where you entered into an agreement, you didn't think about it, or you didn't otherwise satisfy Stark. This gives you another option. As long as the value is less than $5,000 per year, then you may be able to fit within this safe harbor. There's a kind of a catch-all or pretty broad safe harbor that applies to fair market value as long as you are paying fair market value, but there's got to be a bunch of other conditions that apply. There's safe harbors for space or equipment leases, timeshare arrangements, recruitment and retention of physicians and non-physician providers, nurse practitioners, or physician assistants, non-monetary compensation up to, I forgot to check on 22 amounts. It's right around $429 per year. It may be up there probably around $435 or something like that for 2022, I suspect. There's a safe harbor for hospitals that can provide certain medical staff incidental benefits, for certain professional courtesies that hospitals and other entities can provide as long as they satisfy criteria, obeying malpractice subsidies, isolated transactions, including settlements, payments by a physician. Now, this is an important one because the Stark now allows, well, this payments by a physician has been in place for quite a while, this safe harbor, but the CMS that enforces Stark had interpreted that extremely narrowly, so there really didn't help you at all. In 2021, when they issued their commentary, they broadened the interpretation of that. So now arrangements that may not have fit within the safe harbor in the past, they may now fit within this payments by a physician for items or services. There's a safe harbor for charitable donations by a physician, compliance training, indirect compensation arrangements, referral services. And then in 2021, the government, again, broadened Stark to accommodate like anti-kickback statutes, certain value-based care arrangements, health as well as cybersecurity technology. Bottom line there is if you've got a relationship with a referring physician or the physician's family member, and that physician's going to be making referrals to you for designated health services, you need to make sure that you structure that arrangement to fit within these Stark regulations or seeking a favorable advisory opinion. There aren't as many advisory opinions for the Stark as there are for the anti-kickback statute, but what there are, you can go to the government's website, CMS website dealing with Stark. It's got the list of advisory opinions that you can look at. There are also FAQs. There are as a list of designated health services listed by CPT codes, but it only applies to certain types of the designated health services, not always. All right, that is a brief overview of Stark. Let's talk next about the Civil Monetary Penalties Law. The Civil Monetary Penalties Law is actually kind of a catch-all that covers a bunch of different types of conduct, including things like submitting false or fraudulent claims, violating the anti-kickback or Stark law. That's the one that allows the government to impose civil penalties. Violating EMTALA, failing to report and repay an overpayment, failing to grant timely access if the government shows up and wants to look at your records, misusing, improperly using HHS, CMS, or other government names, failing to report adverse action against providers. But the ones I wanted to focus on today are the following three: offering inducements to program beneficiaries, offering inducements to physicians to limit services, and submitting claims for services ordered by or contracting with an excluded entity. First, let's talk about prohibiting remuneration to beneficiaries. So the Civil Monetary Penalties Law, similar to the anti-kickback statute, prohibits you from offering remuneration to a Medicare or Medicaid beneficiary if you know or should know that it is likely to influence such beneficiary to order or receive services from a particular provider or supplier. So in addition to the anti-kickback statute, you could also be violating the Civil Monetary Penalties Law if you are offering these inducements to patients, Medicare or Medicaid patients, to come to you to get services. What are the penalties? $22,000 per violation, and also potential exclusion from Medicare or Medicaid. Now, remuneration is defined in the statute to include anything of value, including but not limited to items or services for free or less than fair market value unless you satisfy certain conditions, and the waiver of copays and deductibles unless, again, you satisfy certain conditions. So if you decide to waive copays or deductibles or discount co-pays or deductibles, guess what? That is a violation of the Civil Monetary Penalties Law unless you can satisfy certain criteria. Now, the statute defines the remuneration, or the regulations define the remuneration to exclude certain things. These function as essentially safe harbors under the Civil Monetary Penalties Law, including waivers or co-pays based on financial need or after failed collection efforts if certain conditions are met. I'll talk more about that in a minute. If the items or services, it doesn't include the provision of items or services if there's a documented showing of financial need and certain additional conditions are met. If there's certain incentives to promote, you can offer certain incentives to promote delivery of preventative care, certain types of preventative care, again, if certain conditions are met. If you fit within an anti-kickback safe harbor, then you're okay under the Civil Monetary Penalties Law. There's certain provisions for retailer coupons, rebates, or rewards that would apply to things like pharmacies at a local grocery store, or any other remuneration. This is kind of the catch-all. Any other remuneration that promotes access to care and poses a low risk of harm to patients and federal health care programs. That's a little bit gray, a little bit ambiguous. In the materials that I provided to you, I gave you an article that I drafted that goes into those various safe harbors under the Civil Monetary Penalties Law in more detail. So that is the law, one of the laws, along with the anti-kickback statute, that prohibits you from offering inducements to patients to receive services. There's a separate law under the Civil Monetary Penalties Law that prohibits a hospital or a critical access hospital from knowingly making a payment directly or indirectly to a physician as an inducement to reduce or limit medically necessary services provided to Medicare or Medicaid beneficiaries who are under the direct care of the physician. To understand this, again, you got to step back to the background. When the government switched to the DRG system for hospitals, the government was concerned that, hey, now the hospital gets paid X dollars for this episode of care, and that creates an incentive for the hospital to operate more efficiently. The government was concerned about situations where the hospital may go to physicians and say, hey, you help us cut out costs and we'll share some of those costs with you. And therefore they came up with the Civil Monetary Penalties Law that prohibits you from offering those inducements to those, that prohibits hospitals and critical access hospitals from offering those inducements to physicians to limit services. Now, a few years ago, it used to apply to any services, so it was very broad and created a lot of problems. A few years ago, they modified that so it only applies to an inducement to reduce or limit medically necessary services. So you can always pay to reduce non-medically necessary services, but this just prohibits reducing or limiting medically necessary services. What are the penalties? Well, $5,600 per violation, and also you can be excluded from Medicare or Medicaid. You would probably also have a Stark issue and also an anti-kickback issue in those situations. Now, you may be thinking, well, wait a minute, isn't this what ACOs and the Medicare Shared Savings Plan, that type of stuff, isn't that what it's all about, right? Those types of gain sharing arrangements, isn't that what those are all about? And the answer is yes. If you structure your deal to fit within those government parameters, then you're okay. But if you're trying to do that on your own, you better be careful and at least consider the application of the Civil Monetary Penalties Law. Finally, under the Civil Monetary Penalties Law, it prohibits it basically says that if a person has been excluded from participating in the Medicare or Medicaid program because they engaged in fraud or the like, that person cannot order or prescribe items or services that are payable by federal healthcare programs. Well, that makes sense. But not only that, it goes on to say that, and no one else can submit a claim for an item or service that was ordered or furnished by an excluded person. So if you've got a physician that was excluded that's ordering services at your facility, you can't bill Medicare or Medicaid. You can't submit a claim for that excluded physician. Not only that, but if an owner of an organization was excluded, you can't allow that person, whoever it is, to maintain an ownership interest if that entity is going to participate in Medicare. Not only that, but if you are an entity, you cannot hire a contract with an excluded entity to provide items or services that are payable by federal programs. And that has been construed very broadly. It not only applies to hiring an excluded physician or an excluded provider, but would also apply to anybody else you hire if any of that person's salary or compensation is going to come from Medicare or Medicaid dollars. So for example, I've had situations where a client hired an excluded individual in their payroll or hired it in their billing and accounting. In those situations, that can violate the civil monetary penalties law, and the government can come back against you or penalties. What are the penalties? Well, again, $22,000 per item or service that was ordered by that individual, or treble damages for the amount claimed or you were paid. If you submitted claims in violation of this, you'd have to repay the amounts back to the Medicare and Medicaid, and you can be excluded from Medicare and Medicaid. The government usually has a process, a kind of a formula for coming in there and determining the amount you're going to have to repay if you hired a person or contracted with a person improperly, and it usually depends upon the amount of the time limit and the amount that you received, a percentage of the amount you received from Medicare or Medicaid. The bottom line is you do not want to hire or contract with excluded individuals. Well, how do you know whether they're excluded? Well, you've got to check the list of excluded individuals and entities on the OIG's website. Now, note that these rules under the civil monetary penalties law, it only applies if you know or should have known that the person was excluded. Well, because the government posts the list of excluded individuals on a regular basis, you're probably deemed to have known if you failed to do checks. So you need to be checking on a regular basis. How often do you need to check? Well, the government really hasn't said. A few years ago, Medicaid CMS said you ought to be checking monthly for employees and providers. The Medicare didn't go that far. In the CMS Supplemental Hospital Compliance Program guidance, they said you should check when you hire or contract with that entity, and at least annually thereafter. Since that time, they've kind of walked back and suggest that no, you should be checking at least for your contracted, your employees, your contractors, and probably your medical staff members on a more frequent basis. The only really safe way to do is to make sure you're checking monthly. Other than that, it might be a bit uncomfortable if the government comes after you. Note that could also apply to vendors. How often do you need to check for them? Well, it seems the government gives you a little bit more leeway on that. You should be checking before you enter into the contract with them, maybe periodically thereafter, but I don't think the government would come after you like they would for your own employees, your own independent contractors, providers that are rendering services to you or through you at your facility. All right, those are the main statutes. Those aren't all the statutes. You also have to be concerned with certain federal criminal statutes dealing with fraud and abuse, including the healthcare fraud, false statements relating to healthcare, and so forth. Now, what about private payers? The statutes we've talked about so far, by and large, with the exception of ECRA, they apply to if you're doing government business, right? If you're engaged in Medicare and Medicaid. What about if you're just dealing with private payers, or do these same statutes apply? Well, Medicare or the anti-kickback statutes, STARK, generally don't apply to private pay situations, but other statutes might, including the healthcare fraud statutes, ECRA. The government in some states, some districts, they're using the Federal Travel Act to go after entities who engage in fraudulent or wasteful misconduct, abusive misconduct with private payers. In addition to the federal statutes, you've got to be concerned about state statutes. For example, some states, like I happen to be here in Idaho, Idaho has an anti-kickback statute that applies to private pay situations as well as government payers. So we've got to be concerned about that, the state anti-kickback statute in Idaho. States may have their own mini Stark laws or self-referral laws. Fee splitting statutes usually appear under the Medical Practices Act. There could be insurance fraud statutes or consumer protection statutes that may be implicated. The bottom line is, don't assume that just because you're dealing with private payers that all bets are off. You can do whatever you want to without consequences. Certainly, if you're engaging in fraudulent conduct, you can get nailed. Even if it's not fraudulent, the private payer could still come after you under any number of theories for breach of contract, including your managed care contract, common law fraud or misrepresentation, unjust enrichment, restitution, interference with contract, or others. In the materials I provided to you, I've given you an article that I actually presented at a national program dealing with private pay fraud and abuse situations. All right, with that background concerning the laws, let's apply those laws in some of the common situations. Let's talk first about patients. So primarily, we're going to be talking about government beneficiaries. So if you're dealing with government beneficiaries, again, if you're giving those government beneficiaries any inducement, any remuneration in order to get services from you, there is a potential violation of the anti-kickback statute, civil monetary penalties law, maybe applicable state laws. That could be gifts to those patients, including a gift basket, gift card, basket of new products for new mothers, etc. I had a situation where I was driving down the road once. I looked up and I saw that one of my clients had posted something up on a billboard that said, "We'll, come to us and deliver your baby, and we'll give you free diapers for a year." I got back and said, placed a call to my client. You may want to think that. Refer a friend incentives, free exams or services, maybe as part of a community screening program. If you're offering free exams or services, is that remuneration? Does that have benefit? Yeah. Free equipment, supplies, or drugs, free meals, free transportation programs, parking reimbursement, waiver of copays or deductibles, insurance-only billing, write-offs, paying premiums for the patient, anything else of value that does not reflect fair market value, then there's a real potential that it could violate these statutes. Let's talk about some of the specific situations. Let's talk about free or items or service, discounted items or services to patients, particularly government beneficiaries. Under the regulations, you may offer free or discounted items to government beneficiaries if the remuneration is not likely to influence the beneficiary to order or receive items or services payable by federal or state healthcare programs. If it's kind of a one-off, the patient's leaving out the door and never going to return again, there's not much of a risk because it's not likely to influence them to order or receive benefits in the future. On the other hand, if you're giving that to them as an inducement to get them to come back, that's problematic. The government has said that they will not go after you if this item or service that you're offering to these beneficiaries is of low value. That means each item or service is less than $15 and the aggregate number of these that you give to the patient is less than $75 per patient per year. So I guess you could give a total of 5 gifts of $15 each to a patient per year to reach that $75 aggregate. Now, we don't have a similar statement concerning the anti-kickback statute, but if you're going to comply with the civil monetary penalties law, I doubt that the OIG would tag you for the anti-kickback statute. So this probably would also apply to the anti-kickback statute. The government has also said that you could offer free or discounted services to government beneficiaries if there is a demonstrated financial need. Now, that is a real determination that this person has financial need. It has to be a good faith determination that the beneficiary has need, or you've tried to collect from him and you just can't collect blood from a turnip. It can't be offered as part of an advertisement or solicitation, so you can't use it in your marketing to say, hey, come to us and we'll give you this deal if you satisfy financial need. It can't be tied to the provision of other federal program business, like, okay, we'll give you this break on this. It's kind of like a loss leader at the car dealership. We'll give you this free or discounted service if you get these other services. That doesn't work. And there has to be a reasonable connection between the item or service that you're providing and the medical care of the beneficiary. It's not like, hey, come and do this and you get a free, iPad or something like that if the iPad's not related to their care or treatment. The government's also said that you could offer free or discounted items to government beneficiaries if you fit within an applicable anti-kickback statute safe harbor. If the item or service promotes delivery preventative care, but that's a little bit misleading because it only applies to certain types of preventative care that are set forth in the government's guide to clinical preventative services. And even then, it has to satisfy certain criteria. There is that catch-all that you can provide the services if they promote access to items or services payable by Medicare and Medicaid, so long as it does not interfere with clinical decision-making, increase the cost of federal program or beneficiary, or raise patient care concerns. So you kind of have to look at the whole situation and see whether or not you can satisfy that criteria, but it's not a black and white test. In the materials, again, that article that I provided to you, it'll break that down and discuss that application more. What about free test or screening? I see this all the time, right? You want to participate in some community events, so come to us on this day and we will provide free test or screening. Again, that can implicate the civil monetary penalties law. But the government has issued an advisory opinion it involved a situation where the hospital was providing free blood pressure checks. And the government said under those circumstances, we would not go after that hospital because that free service, that free item was not conditioned on the use of any items or services from any particular provider. The patient was not directed to a particular provider. The patient was not offered any special discounts on follow-up services. And if the test shows the abnormal results, the visitor is advised to see his or her own healthcare professional. So it's not a situation where you show up, for example, free diabetes screening. And if you come back high, okay, well, let me take you over here to our diabetes clinic, and we'll get you started right here. That would be problematic because you're directing that person over to your facility. If you're just simply providing it, you give them back the results and direct them to follow up with their own healthcare provider, then that's probably going to be okay. But again, those advisory opinions are only binding between the parties. You're probably going to be okay though if you follow those criteria that were set out in that advisory opinion. Now, some services may fit within, if you're providing those free tests or screening, it may fit within one of those other exceptions, like for certain preventative services or services that promote care and pose a low risk of fraud and abuse. If the service you're providing is really worth less than $15 per time, then you could fit within that de minimis exception of the $15, $75. What about free transportation programs? There's actually an anti-kickbacks safe harbor dealing with local transportation programs, depending on the type. So if you're going to want to offer free transportation to your patients, you would want to look at and see whether or not you can structure that to fit within the safe harbor requirements. I'm not going to go through those. Alternatively, if the value of that transportation is just less than $15 and you don't do it more than 5 times per year, you could probably rely on that $15, $75 minimum. What about waiving copays or deductibles? Well, if it involves government beneficiaries, then again, the government has said that is remuneration under the Civil Monetary Penalties Law and presumably the anti-kickback statute. You may ask, well, why is the government concerned about waiving copays or deductibles? Because that's money coming out of your pocket, right? That's not money coming from the government. Why do they care? Well, the problem is those copays and deductibles stop the patient from getting services that they really don't need. If they don't have any skin in the game, if they don't have to pay anything, then they may engage in overutilization, get services they really don't need. So the government wants to make sure you're collecting those copays and deductibles. And if you're not, guess what? That is a potential civil monetary penalties law as well as violating other laws. But the government has said that you can waive copays or deductibles if you make a good faith determination that the beneficiary is in financial need or you are unable to collect after reasonable collection efforts. Again, it's not offered as part of any advertisement or solicitation, and it's not offered routinely. So you're not doing this on a regular basis and basically undercutting yourself for everybody who comes in to insurance only billing or those types of situations. The government has suggested in order to document financial need, you should document factors such as the local cost of living, the patient's income, their assets and expenses, the patient's family size, the scope and extent of bills, and so forth. And by the way, they've indicated that one time may not be enough. You should periodically reevaluate the patient's situation to make sure that there still is that ongoing patient need. You can also waive waive copays or government copays if you satisfy an anti-kickback safe harbor. There's a specific safe harbor that applies to hospital inpatient stays. Those are the rules for government beneficiaries. What about if you're going to waive copays or deductibles for private pay patients? You're just not going to collect them because that creates an incentive for the patient to come and see you. Well, your private payers don't like that, and that would presumably violate your contract with the private payers, and therefore they could sue you or terminate you from their contract because you have violated their provisions. So be really careful before you waive or discount copays under your private pay situations. What about if you're not just going to write off the copay or deductible, you're not going to engage in insurance-only billing, you're not going to bill at all. Well, in that case, there's probably less risk because the payers are happy, right, if they don't have to pay anything, unless you're using it as an inducement to get other services. So writing off the entire bill is safer than just writing off copays or deductibles, but it's not necessarily going to get you out of the woods. If you are going to do that, you're going to want to document legitimate reasons why you're doing it. You're not doing it as a loss leader to collect other services down the road. You would want to document that there's a reason for doing that, such as the patient's unable to properly, or you're unable to properly bill for the services. Maybe you failed to follow the regulations. It's substandard care. You're basically writing off to avoid as a settlement to avoid litigation. So it's a resolution of a legitimate dispute, or there's documented financial need. The OIG has suggested that when it comes to these writing down bills or writing off bills because of financial need, that you should have a reasonable set of financial guidelines based on objective criteria that documents real financial need, and you recheck the patient's eligibility periodically. What about professional courtesies? These are situations where maybe you offer professional courtesy to staff of another physician or another physician's family. Well, are you doing that in order to get referrals? If so, then there are potential problems under here. The general rule is that there is no anti-kickback or civil monetary penalties, safe harbor. So if you're going to do that, you're going to need to see whether you can fit within another safe harbor, including the $15.75 aggregate pay. That may apply if the service you're providing is worth only $15, but that probably isn't going to apply. The bottom line is you better be really careful about those professional courtesies that you're offering. If you're offering it to another physician or a family member, then that's going to implicate Stark. And Stark does have a safe harbor that applies to professional courtesies, but you got to satisfy certain criteria. You have to have a formal medical staff. You have to have a written policy that's approved in advance. It has to be offered to all physicians in the service area, regardless of referrals. It cannot be offered to government beneficiaries unless they're showing a financial need, and you got to make sure it does not violate the anti-kickback statute. What about if you're offering free or discounting items or services to your employees? It's just an employee benefit that you offer to your staff. You're not going to charge them, or you'll allow them to get a certain amount of services at your clinic for free. Well, if you're going to engage in insurance-only billing, you're just going to write off the copays or deductibles. Well, you still got the same problems that exist under those other situations that we already talked about. Also, if you're going to offer free items or services to your employees, beware the tax implications, because that is essentially just more compensation. And remember, you got to pay tax on any compensation that you're offering. So unless you've structured that to fit within your employee benefit plan, consistent with ERISA laws, then you need to consider the tax ramifications. So if you are offering those types of benefits to your employees, the free services, make sure that you've worked with your employee benefits lawyer or your employee benefits advisor to ensure that those are rolled into your employee benefits plan properly so that you can avoid taxes. What about prompt pay discounts? That's common these days, especially with high deductibles or other situations. Can you offer prompt pay discounts to government beneficiaries? Well, again, if the government has issued an advisory opinion where they said, yeah, you can, so long as you satisfy the following criteria. The amount of the discount relates to the avoided collection cost. So it's not done as a loss leader, but you're waiving the amount that you're discounting is done to just avoid your collection costs. It would cost you $20 to collect on it or $200 to collect on it. So we'll waive or discount it at $200 so that we can get it and avoid those collection costs. It has to be offered to all patients for all services without regard to the patient's reason for admission, length of stay, or DRG. So you're not only offering this to your high-paying, orthopedic cases. You can't advertise it so as to solicit business. So you're not out there advertising, hey, come to us, we'll give you the prompt pay discount. You're advertising that in advance in order to invite people in. You need to notify the private payers of the program because remember, offering that discount may violate the private payer agreements. And the cost cannot be passed on to Medicare, Medicaid, or other payers like on your Medicare, Medicaid cost report. Those are kind of the guidelines that the government has issued in that advisory opinion. Again, if you're going to offer those private pay discounts in private payer situations, beware your payer contracts because they may not allow that. They generally require you to collect the copays or deductibles. And if you're unilaterally writing off part of that, then you're not complying with your payer contract. What about self-pay discounts? That if the patient pays for this stuff themselves, that you're going to give them a discounted rate. Well, in most states, providers may generally charge different patients or payers different amounts. I get this question a lot. People say, well, we've got to charge everybody the same amount, right? No, not in most states. In fact, you don't, right? you negotiate with different payers for different rates all the time. You're not always charging everybody the same rate. So in most states, the providers may generally charge different rates and different amounts. The payment is a matter of contract between the provider and the patient or the payer. You can negotiate rates with the payers, including the patients. And so you can negotiate rates for discounts or self-pay patients, but there are limitations. In some states, they do place limits on the amount that you can charge. For example, in some states, you can't charge insurers more than self-pay patients, or conversely, you can't charge self-pay patients more than you would charge the insurers, but you have to check your own particular state law. In addition, if the facility submits a cost report, so like you're a hospital submitting a cost report, there is information from the Medicare manual that indicates the charge structure should be applied uniformly. Now, some people have said that that means you can't give these self-pay rates. I have never seen it enforced that way. It's possible it might be, but I don't think it's a high risk. But just beware if you're submitting cost reports, that's a potential concern. There is a limitation for FQHCs under the MedLearn, at least last time I looked at it, which said that charges must be uniform for all patients. So FQHCs may have their own requirements. And in some states, it will allow payers to enter into most favored nation clauses. So you agree with the payer that you're going to give them the best rate you give anybody else. So if you're giving self-pay patients a discount, then you may be obligated by the contract to pass that on to your payers. In Idaho, we can't do that. In a lot of states, they prohibit those most favored nation clauses, so it may not be a concern, but be aware of that. Also be aware of the substantially in excess rule. That Medicare substantially in excess rule says that the OIG may exclude a provider who charges Medicare substantially in excess of the provider's usual charges. So if you have a large volume of self-pay patients and you're giving them a rate that is lower than the Medicare rate, you may be effectively limiting your ability to charge the Medicare rate. You may be required to charge Medicare no more than you would charge those self-pay patients. Now, the good news is the guidance that we've been given from the government is in evaluating whether that applies. The test is whether the provider charges more than half of its non-Medicare or Medicaid patients a rate that is lower than the rate it charges Medicare. And usually you don't have self-pay patients that are more than half of your patient population. So you're probably okay in that situation, but you may have to look at it by case, the type of procedure you're providing, and look at whether or not compare the rates you're charging self-pay versus the Medicare rates to make sure you're not going to get in violation of this. What about if you allow the patient to pay cash instead of billing the payers? Can you do that? Well, Medicare, Medicaid, and most private payers generally prohibit you billing the patients for covered services except for copays or deductibles. Your contract with them will say, no, you bill the patient for the copays and deductibles. You can't charge them more than the copay and deductible. Instead, you got to bill us. Well, could you circumvent that if you want? Well, not necessarily and comply with the contract, but remember under HIPAA and the HITECH Act, they modified HIPAA to say that it gives the patient the right to decline to allow you to disclose information to a payer for payment purposes if the patient pays for that episode of care themselves. And the government, at least HHS in the context of HIPAA, said that rule trumps the Medicare rule. So if a patient comes in there and says, instead of billing Medicare, I want to pay for it myself, then HIPAA would prevent you from billing Medicare for that if the patient pays for it itself and instructs you to not to bill Medicare. In addition, to the extent that you've got a contrary contract language with your payer, well, HIPAA is the law, right? So the law always trumps the contract. So it doesn't matter what the contract says. If the patient tells you not to bill your payer, then, and all it is a contract requirement, then you got to comply with the HIPAA requirement. Now, if there is a state law that requires you to bill the payer, then HIPAA would not trump and you'd have to comply with the state law. The bottom line is, if you want to engage in these cash-only situations, HIPAA gives you a hook to do that. Realize, of course, there are consequences with that. You may not like it because, if you're going to go down that path, you got to maintain protections for that information to make sure that no information gets to that payer down the road. So there is an avenue there, but be careful about going down that road. All right, just another quick one I didn't put in the slides, but something that is becoming increasingly common is, can you pay for the insurance premiums for a patient? Let's say a patient has insurance or maybe has COBRA, but they're going to lose their insurance, but they want to get a very expensive procedure, and it's going to be a very lucrative procedure for you, maybe a big orthopedic procedure. Could you offer to go in there and pay that patient's premium in order to keep that insurance in place so that you can bill the insurer? Well, the general rule is you may be okay under the, there is potential for, if you're offering that as an inducement under the Medicare or Medicaid, it could potentially violate the anti-kickback statute or the civil monetary penalties. So you'd have to evaluate that. Under the COBRA guidance that issued, they seem to contemplate that situation, so it may be okay. What about if they're on the government plans under the ACA Affordable Care Act? Can they do it under those? That actually went up to HHS. HHS, originally the director said, yeah, you can do it. Then they walked back a little bit and they said, we don't like it if you do that because we think that that's going to screw up the actuarial tables. And so they encouraged payers to refuse or put in their contracts to refuse to allow providers to pay for those premiums. So you'd have to check your individual payers. The bottom line is be careful in those situations. It may not be strictly prohibited, but you may have to look at your payer contracts. All right, let's talk briefly about remuneration to or from referring providers. Remember, anytime you've got a financial relationship with a referring provider, especially if that provider is referring items or services payable by federal healthcare programs, you got to be concerned about those federal statutes, including the anti-kickback statute. If it is a physician, you've got to be worried about Stark and the like. That's any financial relationship, right? And that is very broad. It's not only a contract, it's not only just money. It could be free gifts, free space or equipment for your discounted space or equipment, professional courtesies, incidental benefits, insurance, and the like. The bottom line there is if you've got relationships with physicians or their family members, you need to make sure that you satisfy a Stark safe harbor as well as look at the anti-kickback statutes if that physician is going to be referring items or services payable by Medicare or Medicaid to you. If you're dealing with financial relationships with non-physicians like NPs, PAs, those types of situations, you don't have to worry about Stark, but you still would have to worry about the anti-kickback statute. So make sure that you look at that relationship and that you structure the arrangement to fit within a financial relationship. Just quickly, a couple of the key ones are employment contracts. The bottom line here is it's pretty easy to satisfy the safe harbors for employment contracts, especially for under the anti-kickback statute. Stark, it's pretty easy. In order to satisfy Stark, if it's an employment contract with a physician or a physician's family member, you just have to have the contract for identifiable services. It has to be fair market value for the services that are provided, and the compensation can't be based on the volume or value of the referrals. It can be based on the services the physician personally performs because that's not a referral, but it can't otherwise be based on the volume or value of referrals. And it has to be commercially reasonable. Stark would allow you to require employed and contracted physicians to refer services to you. If you employ them, you contract with them, it only makes sense that you can require them to refer services to you within the scope of what you do. But there are requirements that go along with that. I've got an article on that. If anybody wants that, I can send it over to you. The reason I bring this up though is it used to be that employment contracts to satisfy Stark did not have to be in writing. But if you are going to include one of those requirements that the compensation or that you're going to require the physician to make referrals to you, then you've got to make sure that that contract is in writing. That's a change effective January 2021. For independent contractor arrangements, the Stark and the anti-kickback statute are more strict. You generally have to have a written agreement. It has to be signed by the parties. In recent CMS guidance, that says it doesn't necessarily need to be a written contract per se, as long as you've got contemporaneous written documents that confirm the terms and it's signed by the parties. So you could take emails and things like that, combine them together as long as you can create what the contract was, then it's not necessarily a Stark violation, but you may still have AKS issues. The terms have to remain in effect for at least a year, but under CMS recent guidance under Stark, you can actually amend the contract compensation during that 1 year period, as long as you otherwise satisfy the requirements. The compensation has to be set in advance, consistent with fair market value, and again, cannot be based on the volume of value of referrals or other business generated between the parties, and it has to be commercially reasonable. For group practices, remember Stark and the anti-kickback statute for that matter apply to referrals within the group, but Stark has exceptions for referrals within the group. It's got the in-office ancillary services and physician services agreement. But in order to satisfy those, you have to function as a true group practice. You can't just come up with a bunch of physicians who decide to call themselves a group and then exchange referrals and share money back and forth. You can't do that. You have to function as a true group. So in order to do that, you got to satisfy the group Stark safe harbor for the group practice. You have to operate as a single legal entity. You must have at least 2 physicians who are members. At least 75% of the patient services have to be furnished by and billed through the group. So be careful about bringing in an outsider to allow him to provide services for the group if that's going to mess up this overall 75% test. The overhead expenses and income have to be distributed per a method that's determined before receipt of the payment for services. It has to be operated as a unified business with centralized management and consolidated billing and accounting. The members of the group have to conduct at least 75% of the physician-patient encounters, and the compensation cannot vary directly based on referrals. This is the one that you usually get tripped up on. If you have a strictly eat what you kill situation in your group practice, because there are certain requirements for the group practice that they can't be directly based on referrals. There are a couple of safe harbors depending on whether or not you are paying productivity bonuses. You can pay the physician based on the services the physician personally performs or their incident to services, but not necessarily strictly based on the services that they order that are performed by others or ancillary services. There are limitations and exceptions to that. Similarly, if you're going to just share profits, again, in order to fit within a group practice and fit within the Stark safe harbors, you need to make sure your share of profits are set up to satisfy the compensation structures. The most important of which is if you have at least 5 physicians in the group, then the share of profits, you can't break out those. If you're going to share profits based on what an individual group of physicians are going to do, you've got to have at least 5 physicians in that group. So you can't have everybody just get their own profits and ancillary services that they themselves bill and order. You'd have to have at least 5 people in that group. Again, there are some nuances there. The bottom line is make sure that you look at those compensation arrangements. I think in the materials I provided to you, I gave you an article discussing those. There are different requirements. If the physician's going to have an ownership interest or another provider is going to have an ownership interest in a separate legal entity, that they're then going to make referrals over to that entity. There are safe harbors for under Stark, the most important of which, of course, is the group practice safe harbor or the rural provider exception. Under the anti-kickback statute, there are a small investment safe harbor. It's pretty hard to satisfy. The bottom line is be careful if you're going to get an ownership interest in a separate legal entity and make referrals over to that entity. You need to look for a safe harbor, evaluate safeguards that you can put in place to minimize. Those are just some of the safe harbors that apply to kind of your key contractual relationships. There are other safe harbors that apply to other types of relationships that exist out there, leases, recruitment arrangements, the like. The bottom line is if you're going to engage in those, especially with physicians or physician family members, make sure that you call up the safe harbor and apply there. All right, in the interest of time, I'm going to skip through the repaying and overpayment situation. Just beware of this, that if you do have a problem, if you've got a situation where you have received payment in violation of the rules we've talked about today, or you've otherwise received an overpayment from the government, then you have an affirmative obligation to report and repay that within the later of 60 days after that overpayment is identified, or the date the corresponding cost report is due. If you fail to do that, that turns into a False Claims Act, and the government can come after you for those penalties, which can add up awfully quickly. The slides talk about how you determine what an overpayment is and the timing for that. I'm not going to go through all of those. If you do have that overpayment, you generally have a couple of options. One is you can go to the Medicare contractor and go through their repayment process. They should have on their website an option for doing a repayment. So you just do a disclosure and repayment back to the federal contractor. That's usually what I would always prefer to do. The other alternative is you can go to the OIG if you think that there's a violation of the anti-kickback statute or civil monetary penalties law, or you can go to CMS if there's a Stark law violation. I would not go to the OIG unless you have to. It has to be a pretty serious situation. Once you get the OIG involved, there's no telling where they will stop. And it's kind of like the bull in the china closet. You know, it can open up a lot of other problems for you. Now, if there wasn't a clear violation, then you're better off doing it than not. But I would be careful about just simply launching into that OIG process. The process with Stark and CMS, historically, I think that has been a lot more fair. If you do that CMS self-disclosure protocol through CMS for Stark violations, the government has been pretty reasonable in those responses, and generally the ones I've been involved in, the government usually only requires a repayment that's a few cents on the dollar. But again, it would depend upon the particular circumstances. The bottom line is if you've got an overpayment situation, you're probably going to want to talk to an attorney or somebody who knows about the relevant rules to evaluate your risks and make sure that you address it in an appropriate sort of way. All right, I've got some other key suggestions there for you. In the interest of time, I'm not going to go through those, but you should have those in case you need them. If you need additional resources, these laws are explained on the government's website. They've got videos, they've got publications there for you. They've also got compliance guidance. The government has issued compliance program guidance for different types of entities, including hospitals, physician practices, long-term care, and the like. If you haven't looked at those for your particular provider type, you ought to call up there and get those. Among other things, they will lay forth the elements for an effective compliance plan. And perhaps more importantly, they will identify key risk areas for compliance in those particular areas, and those are helpful in evaluating your compliance. We also have a whole bunch of free resources on our website in order to access our webinars or our publications, our articles, similar to those that I provided to you. You can just go to this website and access those. Those are all there for free, just because we are nice folks. That is it. I appreciate it. I apologize for going over a little bit of time, but there's a lot to cover. I see that there are some questions. If you have any questions, feel free to shoot those to me. You can use the chat feature or the Q&A, or just shoot them offline, and I will do my best to respond to you. And I apologize if I haven't responded to your questions in the past. It's been pretty busy. Thank you.